Number 37, Schoch versus Lake Champlain OB-GYN. Counsel, if you just hold on one moment. Gentlemen, you're welcome to stay. If you're going to clear out, do it quickly. Thank you. Counsel?
If it please the court, James Peluso, the law firm of Droyer Boyajian, on behalf of the appellant, Lake Champlain OB-GYN.
Counsel,
If I may reserve 2 minutes.
I'm sorry.
You may
Before I
have
be-
your 2 minutes, sir, for rebuttal.
Could we pick up right where we left off here? And I'm trying to understand, let's stick with the statute first. I understand the respondent's view that the rule should be policyholder means the person who named the policy is in the insured. What would just purely based on the statute, what would your rule be?
Your Honor, the statute in the legislature, when they enacted Section 7307, were very specific in the terminology they used. They used the word policyholder. They did not use the word insured. They did not use the word beneficiary.
So under your rule, who is the policyholder?
Lake Champlain is the policyholder.
Why?
Lake Champlain contracted for the policy, and Lake Champlain was issued the policy. The word policyholder is not defined in Section 7307.
So what if in another case the doctor picked the policy? Same facts, but the doctor says, hey, I like Mutual, Omaha, let's use them. And you say yes. So then you're not the policyholder?
If the doctor contracted for the policy,
No, the doctor just says, I like this insurance company, why not use them? And you say, okay, you can pick the policyholder. You can pick the company.
well, Judge, under that factual scenario, I would still argue that the party who actually bargains for the policy, the coverage, the terms,
So it isn't who picks it, it's what?
who bargains for the policy. And we submit, and let me preface this by saying, under the insurance law governing mutual insurance companies, policyholder is not defined, insured is not defined,
That's why I'm
and
trying
member
to,
is not defined.
that's why I'm trying to come up with a definition. I understand their definition.
So we submit that the court, as it has in prior cases, follow, rules of statutory construction. One, look at the plain meaning of the statute to see what the legislature intended.
So I understand the rules, but what is your application of the rules? What is the test you would have us apply?
I would look at who was the party who bargained for, in this case, the Milmick policy of insurance. And this is very important because the practices had options. They could have went with Milmick. They could have went with a different insurance company. They chose the mutual insurance company because it had its very specific benefits, primarily dividends that would be received. Okay?
And did you have a written agreement with the doctor as to who would get the dividends?
No, in fact, in our case, Schoch's complaint specifically pleads that she did not bargain for any interest in Milmick or any interest in the demutualization proceeds. And she did that to avoid the arbitration provision in the contract. And to follow up on my prior point, Judge, if we can't discern who the policy holder is from the plain language of the statute, we can look to other parts of the insurance law, because the second rule of statutory construction is to make sure that the entire statute is harmonized. And conveniently here, we do have a definition. If we turn to Insurance Law 501 subsection G, it defines who is a policyholder for property casualty policies. And it's very specific. And it states that the policyholder is the person. Policyholder means a person who is contracted with an insurer for property casualty insurance coverage. It can't be any more plain than it is written by the legislature in the statute. Now, the respondent has argued, well, you can't bootstrap Section 501 into Section 7307. But under well-settled principles of statutory construction, this court can, in order to determine.
Who are the parties to the contract of insurance?
In this case, Your Honor,
I mean, there's a written contract, and presumably it has parties. Who are the parties? Who
in
can
this
enforce
case,
it?
it's Lake Champlain and Milmick. And if you look in the record at the policy declarations and the endorsements at 230 to 247, the policy was issued to Lake Champlain all the endorsements are issued to Lake Champlain. Lake Champlain at all times had the ability to select the insurer, here Milmick, select the coverage, terminate the policy. It received the dividends. It received the cancellation refund when the policy was over. The only thing that it had to provide the respondent was coverage. And she acknowledged.
And does the, I'm on the screen, counsel, sorry.
Sure.
And does the policy state that Lake Champlain is the policy holder?
The policy, I believe, identifies Lake Champlain as the policy administrator and identifies Ms. Schoch as the insured. I don't think the word policy holder is used in the.
Is insurer defined in the policy?
We do not have a definition in the record of insured, Your Honor.
Okay, thank you. It does sound like a policy holder, though, the insured, right?
Well, that's what the third department did. It looked to the Milmick plan of conversion to define policyholder. And in the plan of conversion, the definition is a policyholder is the named insured. But if it was that simple,
Did Lake Champlain sign off on the demutualization?
there's nothing in the record, Your Honor, that either party here voted on the plan. And that's a good question the court presents because, who were the policyholders entitled to vote here? In the DFS, they grappled with this issue because during the hearings, this was raised. Who should have had the right to vote on this plan? And who are the policyholders? And they kind of, the superintendent, his decision said, well, it really doesn't matter because nobody objects to the conversion of Milmick to a stock company. We can figure out who the policyholder is and who's entitled to the cash consideration either through this objection protocol, which was very limited in specific to certain types of objections. It did not foreclose an objection by, for example, and this is important, if a policy administrator has not been specifically designated to receive the cash consideration allocated, but nevertheless believes it has a legal right, it can file an objection, and the money will be put in escrow, and it will not be released until there's a non-appealable decision from a court or arbitration panel. So even the DFS recognized that although the conversion was in the best interest of everybody, and nobody objected to that, they wanted the conversion to go through, and they wanted to procure a way to get the money, right? So Berkshire Hathaway was going to, convey this $2 billion. They needed to park it somewhere to allow the conversion to go through, and in the meantime, these disputes have arisen between certain policyholders, or I should say parties, such as Lake Champlain and their insureds. The DFS, they also said the objection procedure provides a reasonable framework for the resolution of these disputes between certain policyholders and entities that claim to be policy administrators. Importantly, the objection procedure does not in any way impact any person's rights to resolve their dispute in any form of their choosing or as required by contract or law. Rather, the purpose is to create a category of disputed claims. In this dispute resolution process that the DFS set up was completely voluntary. You were not required to participate in it. You could very easily have declined to participate in this procedure and brought your claim to either arbitration or court.
Thank you, counsel. Counsel?
Thank you. May it please the court, Justin Heller with Nolan Heller Kaufman in Albany on behalf of the respondent. As a threshold matter, the appellant's main argument, as I understand it, is that the third department failed to properly interpret 7307E3 in deciding which party was entitled to the consideration, and instead improperly relied on the terms of the plan in awarding the money to the respondent. But the insurance law expressly delegates jurisdiction to the DFS to ensure that a plan of demutualization is consistent with applicable law, fair and reasonable in the best interest of policyholders and the public. And that's what the DFS did here in its written decision, and specifically considered and rejected the same statutory construction arguments that the appellant here and all of the appellants on these appeals are making. And so, as a result, the only way in which a party could challenge the terms of the plan or the DFS decision was through a timely Article 78 proceeding. And in fact, such a proceeding was brought in Westchester Supreme Court, and it was dismissed as moot because the transaction had closed and $2.3 billion had already been distributed out. And the court also found that the DFS decision had a rational basis and was not arbitrary or capricious. So as a result, the plan governs who gets the money, and I think the third department in this case, as well as the second and fourth departments, were completely correct to apply or to look to the plan's terms in reaching their result. And I believe that these statutory interpretation arguments are really barred at this point under the doctrine of collateral attack, because the DFS decided that the plan, that approved the plan. The appellant also argues that 7307 does not provide a definition of policyholder. But I think that's wrong. I think 73073 is completely clear that the party who is the policyholder and entitled to the consideration is, in the words of the statute, each person who had a policy of insurance in effect during the relevant period.
Counsel, what about the argument we heard that that language that has been interpreted, at least by the third department, related to payments of the premiums, that if you read that literally, the doctor or nurse would not be entitled to anything because they didn't pay any premiums?
Well, I think as the third and the second departments recognized, that language comes from a section of E3 that describes the formula for allocating consideration between a particular policyholder and the rest of the policyholders. And that is the amount of premiums paid during a 3-year period.
But I think their point then would be, if that's what that means, the actual policyholder paid nothing, so you would get nothing.
Well, I think that's incorrect, because what's I think important to bear in mind here is that while the employer paid those premiums, it paid them on behalf of the policyholder, both as a part of the bargained for consideration between the parties as a part of their employment agreement, and in its capacity as policy administrator, which is the agent for the policyholder. And as policy administrator, the employer is specifically and expressly the agent for certain acts, and those are the payment of premiums, making changes to the policy, and receiving dividends in return premiums. So yes, the employer may have mechanically made those payments, but to the extent that they're made on behalf of the employee, I think it's really the employee policyholder who is deemed to have made those payments. And I guess I would add that, and again, as the second and third departments noted, it's that, that formula language that has the reference to premiums paid relates to the allocation of premiums between policyholders, but it's the other language in 7307 E3 that tells you who is entitled to consideration. And again, that is each person who had a policy of insurance in effect. That could only be the respondent here. Only the respondent had an insurance policy. Only the respondent had any kind of privity of contract with Milmick. And to the extent that the appellant bases its arguments on things like its interaction with Milmick with respect to the policy, or certain claimed indicia of ownership of the policy, all of that flows from the appellant's role as policy administrator. I mean, a good example is dividends. The only reason the employer receives dividends is because the policy holder has designated the right to receive those dividends to the employer pursuant to the policy administrator designation form. But the policy holder did not part with any of her other rights, such as the right to vote, the membership interest, even the right to terminate that policy administrator designation if she so chose. And that also, the appellant refers to, describes itself as having contracted with Milnick for insurance. But again, it's the policy holder, it's the respondent who is the insured, who is the owner and holder of the policy, and to the extent that the employer did anything with respect to the policy, it was as her agent as policy administrator.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
With respect to the policy designation form, and we don't have a completed copy of that in the record here, but assuming that we believe it was filled out by respondent, that is an indicative of the fact that the insured here, Ms. Schoch, recognized that Lake Champlain was the owner of the policy. All the trappings of ownership were vested with Lake Champlain. She agreed to that. She agreed to allow them to administer the policy, collect the dividends, collect the refunds, cancel the policy if they wanted to. And, earlier today, we were
Doesn't that seem in the other direction from what you're saying? That is, that agreement is her giving those things to your client?
Well, it goes to the question that was raised earlier, do you have to have legal title to have ownership or an equitable ownership interest? And this court has recognized before in the insurance contracts, in the insurance context, you don't have to be the named insured or beneficiary to receive the equitable interest in the policy. In the Simmons case, the court imposed a constructive trust on life insurance proceeds, where a spouse had agreed to name his first wife as the beneficiary. He didn't. He named the second wife. The second wife had a legal contract. She was named as the insured. The court came in and said, well, we're going to impose a trust, essentially, and do what's equitable and allow the first wife, who has no contractual privity in this contract, to participate in the life insurance proceeds. So if we're going to go down that road on who's the policy holder and who's the owner of the policy, if it's not clear from the statute and the plain meaning and words used by the legislature, then our argument is that as a matter of equity, Lake Champlain is the de facto owner. And we submit that the unjust enrichment claim survives for that very reason. And the majority of courts throughout the country who have looked at demutualization of insurance companies have come to exactly the same result. They've looked at who paid the premiums and in what proportion were the premiums paid by the employer versus the employee. We cited over half a dozen cases, most of them federal, many circuit courts of appeals, where if the employer paid the premiums, the employer participated in the equitable interest that was distributed. If the employee paid the premiums, then the employee received the equitable interest. Didn't matter who was the policyholder, who was the insured, who was the beneficiary, who bargained, because nobody bargained for that exchange. If anyone here bargained for the Milnick policy, it was Lake Champlain. Certainly not Ms. Schoch. Lake Champlain, if anyone, has an equitable interest in these proceeds since they bargained for the policy. They had an expectation of dividends being paid while Milnick was a mutual insurance company. And once that conversion occurred, that right was extinguished. And how do you compensate a party who's had a right in dividends that's been extinguished? It's through the equitable interest and here the cash consideration. And that was recognized by Chicago truck drivers, which was a federal court case. And the court noticed that when a mutual company...
Counsel, I'm on the screen. But if the money is in exchange for the membership interests, and the employer's not the member, I'm not sure I can follow your argument.
No, Your Honor, I'm not suggesting that it's a a purchase of the stock in the new company.
Okay.
The premiums that were paid were part of the bargain for exchange and when they contracted for the mutual insurance benefits of Milmick, which included the dividends. So,
Yeah, it over here, it expressly included the dividends, but didn't say anything about demutualization proceeds.
well, that's correct, Your Honor. And what we're suggesting is, as a matter of equity, when you're weighing the equitable interest of the parties here, if you can't come to a clear understanding of who the policyholder is under the statute, okay, then you look at examples of, who bargained for the policy, who exhibited, ownership responsibilities, who was the person who had a vested interest in the continuing ongoing concern of Milmick. Here it was the practice. That's why this Lake Champlain went to Milmick. They could have gone to a different insurance company. They didn't. They specifically liked the fact that dividends would be paid and they could lower their premiums for all of their physicians in their practice group. So in weighing the equities of this, we've submitted that.
So then Lake Champlain got what they bargained for, and the employee's the member, and now they get whatever a member would get.
Well, Judge, I would submit that once the company converted to a stock company, Lake Champlain lost what it had bargained for, which was the right to receive dividends.
Thank you, counsel.